Hello, my name is Navneet Singh and this video is on the employment law. Let's begin with the first question. What the question say is, what did the employer do wrong in this situation? In the case of the City of Calgary v Canadian Union of Public Employees, the dispositions assumed by the employer were unlawful and this deprived the employees of fair employment practices. More to it, the employer did not ensure the provision of safe and discrimination-free workplace, dismissed the employee unfairly without a legal reason, and failed to exercise what was due process in workplace management, including handling complaints of discrimination or other related abuse. Employee relations involve providing employer justice, and among the most crucial activities in management is documenting disciplinary measures and the Employment Act. In this case, procedural unfairness ensured by the employer, together with no proper legal reasons for the dismissal of the employee, signified the rampant violation of workers' rights. Further, if there have been cases of harassment or unfair treatment, the act of employer turns a blind eye to workplace wrongdoings as well as act wrongly. Moving further to the second question, the answer is the employer breached employment standard legislation and common law prohibition of wrongful dismissal. Namely, if the case happened in Alberta, Canada, the employer may violate the Alberta Employment Standards Code, which prohibits unfair dismissal, and the Alberta Human Rights Act. In most cases, including unjust dismissals, the employer has to exercise just cause or provide reasonable notice or severance. He did not honor these legal standards, which make the termination unlawful, thus easily actionable. Now, the third question is, what should the employer have done in this situation to comply with the law? The answer would be by following the legal and ethical standards in place in the workplace. One should have followed a fair disciplinary procedure when terminating the employment contract. If the termination was warranted, there should have been a record of all the transgressions leading to the dismissal and the opportunity given to the employee to rectify their actions. If the termination was the result of restructuring or non-performance, the employer should have provided the notice period or severance pay in addition to providing reasonable notice if it was going to be the latter. To have a proper discrimination free workplace, that employee rights are being respected there. Fair warnings, performance reviews, and job termination policies. These are some ways that some employee can follow proper procedures to get away from the wrongful dismissal. Next, our last question is, what legal remedies are available to the employee in this situation? Uh, the answer will be the unfortunate employee has several legal remedies. For example, filing a wrongful dismissal claim if the employee lost wages or benefits. The employee can claim severance pay if the employer does not give proper notice, and that may be in proportion to how many years a person has worked for them. In some cases, employers may negotiate reinstatement or a financial settlement through mediation or legal action, and in this case of discrimination, employees may make an Alberta human rights complaint and other financial damages at their discretion. Thank you. I will attach the reference below.